Good afternoon, ladies and gentlemen. My name is Ronaldo Hilton, the chairperson designee of the New York City Loft Board. Welcome to our November 16, 2017 public meeting. We're going to first turn to a vote of the October 19th minutes. Is there any corrections or comments on those minutes?
Just as a general comment, I know now that we're having these extended discussions about the rules. It's a lot of work for somebody to create the minutes. And I notice when I read through it that sometimes there might be a slight punctuation, or I'm just assuming we're going to kind of let that stuff go. Yeah, rather than.
I mean, I think if there's punctuation that you think affects the meaning of the sentence, then please, by all means, tell us, but, you know, it's a period here or there.
Right, but I get you. The type of discussions that we come forward, it may be very difficult to get the minutes to.
No, I don't remember where I found it, but towards the end, I think the word lead is put in instead of live.
Yeah, that kind of, I mean, but.
Well, no, that sounds like substance. This area.
Should have went. I don't know why I didn't underline it when I read it.
We'll double check that.
We'll do a search for leave and substitute with.
Okay, if there's no other comments on the minutes, is there a motion then to accept the minutes with the correction that was just mentioned by Mr. Delaney? Is there a second? Mr. Roche. Mr. Rivera?
Mr. Butler?
Yes.
Mr. Robert?
Yes.
Mr. Luce?
Yes.
Mr. Delaney?
Yes.
Chairperson Hilton?
Yes.
5 in favor, 2 abstain.
Okay, so we are waiting. Here it comes.
Is this IT?
Okay, we're just going to take a short. Okay. All right, we will resume this meeting. We will now have a presentation of the Loft Board mapping project by Mr. Aidan Alamo. He's the Director of Quantitative and Spatial Analysis for GOV. Don't let the name, this title fool you. He's really a cool guy. But he's going to show us a little bit about mapping and loft buildings. Yes,
Thank you very much, Ronaldo, and sorry about the delay. I'd like to say it's because we're in a new building, but it's really an old building, and there's some issues with the network. But so what we're doing is basically I'm the GIS director for the department. Can everybody hear me? So what we do is a lot of mapping projects, analysis of what's going on in the department and what have you. And Ronaldo came to us a little while ago and he said, you know, we'd like to have something that's public facing, that the public could see what's going on in the Loft board world. So this is a prototype that we have developed, and you're really getting the first view of it. But this would essentially be a public facing application that that could be logged in from the outside, and you could see any information about buildings, look up addresses, you know, really anything that would be of interest in this world. So let me just see if it's also an older machine. So it's a little formatted different. But you know, it gives you basic information about different loft buildings, pending removals, and some of the milestones that are going on in the loft board world. And that's essentially it. This is something that is scalable, so it can be used, really, we're using it internally, but it can be used externally for a lot of different reasons. And we can build on it, and as information is updated, DOB records, it can be reflected out to the public. So that's essentially what we're working on.
So just to clarify, Aidan, so we have all, what, 340?
Yeah, 342.
342 buildings that are loft, in the loft world right now, and they're all mapped out. And basically, when this goes live on our website, which will happen as soon as we want to give the Loft Board members a first shot at it, maybe to ask any questions and also well, want to show everyone, because when it goes live, members of the public will be able to kind of spot any particular building and get information. This is all about transparency and openness, just make sure that information that you need, you don't have to necessarily come to the Loft board window to find it, but maybe by clicking on any particular building, you'll be able to just get the information about, not just about when the building went to the Loft, or the Loft jurisdiction, where it is now in the milestone-wise. It also has a link to the Department of Buildings website, I believe.
Yes.
And the property profile for that building. And so there's a lot of information will be just at your fingertips from home, the comforts of your home. So does any member of the board have a particular question about? Yes, Mr. Carver?
So as data changes,
Sure.
how often will this be updated?
Well, right now, we're doing it basically monthly as we get reports and whatnot, but we are doing a big modernization at DOB, so this could be instant once, once it's up to do that, so.
And I guess after people start using it, and there are additional fields that we think should be on.
Those can be added, yeah.
Yeah, you just have to speak to the members of the Loft board staff, whether or not, if that's something that we can feed to Aiden's group, they'll add that in.
Could you tell us right now what the different colors stand for?
Sure, actually, there's a,
Is
this,
there a key if you still go down to the?
there is, yes.
Okay.
This is an older machine, so it's a little formatted differently. And I would also say that this application is formatted so that it's also mobile ready. So you can see it on tablets. You could see it on a smartphone if you wanted to. It's just a little bit different. The keys are a little bit different. But yeah.
Dark blue, other is what, do you think? The last one, other.
Let's see.
Is there any dark blues?
Yeah.
Well, oh, Aiden, you have a permit, but you have a permit.
You can,
It's a good question.
So
I'll have to figure that out.
other is intended to capture stuff that in no way fit into any of these other categories, but we don't know what that is yet. So it could be that that information was just missing from this data.
I see, okay.
But I'm sure if he go to all the others
Can you scroll back down to
and try to clarify with the Loft board, then of course we'll fill in the blank.
I guess the same question could be asked of what cert under C of O.
Certification was issued, that the Loft board issued certification on the narrative statement process.
Oh, okay.
Maybe
So
what we'll
that's
do
sort of in
is,
between, Frank, so you start with no alt-line file,
Right.
right? And then you should move to alt-1, right? Then you should move to certification, then you should move to permit. Well, I guess alt-1 and open narrative statement, and then an open narrative statement. So then you would move to certification, permit, et cetera.
You don't have to take,
We should arrange them in the order of how things happen.
Can you click on that orange square down at the bottom of Manhattan?
and there's not a designation for those people that have left the law board jurisdiction.
We can do that, but that involves going back through all of the old records. So at this point, we wanted to get up to
No, I
our
understand
buildings.
that. I think it would be a good thing to have, just for general distribution, of how many buildings there were, and that are now off Loft as well as the 340 some odd that are.
Well, you know, as far as putting that on the map, though, you may crowd the map.
You can have a separate.
You can have a separate.
Yeah.
For it.
Yeah, I would like to second that concern, because one of the things we're discovering is there are times that buildings have been brought up to code, they've exited the law court's jurisdiction, but there's no visa stamp in their passport, so there have been people who've had trouble establishing the fact that the building used to be an IMD. So, and plus I think if we had the buildings that have participated in the program and left the program, it would show how successful the program is.
So historical data is good. It's going to take us a little bit of time to get all that.
Yeah, no, understood.
This is,
One other question, you said 342 buildings. Those are the 342 buildings that are currently registered with the Loft Board
okay.
or pending,
No, that have IMD numbers.
that have IMD numbers?
Yeah, active
Right.
buildings,
Okay.
IMD numbers.
All right,
So if there's a pending coverage application, that's not included.
but we think this is exhaustive.
I certainly hope so, because I worked very hard on it.
Yeah. Well, I know one building that's missing is mine, so,
Are you sure?
I don't know.
because it's the only thing even close to where I live is that little orange square. So,
All right, we'll, can you share that information?
sure.
Can you go to the
Yeah.
That's not really-
No. No, my landlord is taking his time.
Enjoying the experience.
I know your building is on the spreadsheet.
Yeah, I know that.
Okay.
Could be.
No.
I know where you live.
All right. We'll look into that. So it's important to note that this is just a work in progress, and, you know, this is, want to show you the potentials here. Does anyone else have any observations or wishes?
Well, I think this is terrific. Great job.
Yeah, that's the Aiden, you know, he did a good job, and he's doing a lot of other things in the department as well. But this is the kind of the stuff that the commission wants to put out there to kind of modernize the agency a little bit, and certainly increase, as I said, the transparency within the agency. All right, thank you very much, Aiden.
Thank you.
We'll get back to you with other stuff. So we're not going to go live until we fix it.
To get a question.
Yes.
Just a quick comment. I'm wondering if there should be a presentation of data as of and a
Yeah.
certain date.
Yes.
Okay. Thank you.
And maybe we will also put, you know, that legend, that little key at the bottom. We'll make sure that those are explained a little bit more. What
Yeah,
like
what they
service
are.
should say, should spell it out.
Actually, it said it above.
Oh, yeah.
Yeah, so, but yeah, we can play with that to make it more useful.
Thank you, sir. Appreciate it. Very good. To item number 4 on the agenda, the Loft Board rulemaking. Last month, you were given a proposed rule drafted by staff. This rule changes the text of 29 RCNY 209B regarding protected occupants and 29 RCNY 210D2 regarding sales of rights. After the meeting, staff realized some text from the old rule were erroneously left out of the proposed rule. It has been added back. In addition, at the request of board members, staff drafted several options for the proposed rule. The options are as follows. Option 1. This is the rule that was presented last month. This option is the broadest option. It protects everyone who lived in the unit during the window period on the effective date of the law, and if there was an adjudication on the date the record was closed. As to option 2. This option keeps the language that the prime lessee is the protected occupant to the exclusion of all others. There's an option 2A. This option protects the prime lessee and prime lessee's spouse or domestic partner. As to option 3, this option is an attempt at a compromise between the two owner positions. One, with the prime lessee and everyone, of course, who was residing in the unit at the applicable time. This proposal protects people who demonstrate they were members of a common household. This proposal also somewhat addresses the issue of an economic connection because a factor to be considered to determine whether occupants are members of a common household is whether there are economic connection between household members, even if there were no direct economic connection between household members and the landlord. This option excludes roomers, boarders, or lodgers, so that mere roommates are not necessarily bound to each other through protection under the Loft law. It's not perfect, but it does take in consideration some of the concerns previously raised. Let's continue our discussion of option 1. Ms. Balsam has some comments based on our last discussion. Ms. Balsam.
Thanks. So we were discussing several things last time. One of the things that you raised, Mr. Carver, was the idea of I just want to get the name of the case, the Manhattan Tenants versus the Loft Court case, where the court said that statutes in pari materia are to be construed together. So I took a closer look at the case, I did some more research. The full sentence in the decision states that statutes in pari materia are to be construed together and as intended to fit into existing laws on the same subject unless a different purpose is clearly shown. So number one is that I think that these aren't necessarily the same subject, rent stabilization laws and the Loft law. So there's a connection, but they're not exactly the same. And number two is that I think that the Loft Board does, in fact, have a different purpose. The Loft law has a different purpose from the straight rent stabilization code in that the Loft law is dealing with the legalization of illegal spaces, the protection of public health and safety, and the prevention of dislocation of people that are living in these spaces. So to summarily adopt everything from the rent stabilization world on the issue of primary residence into an analysis under the Loft law, I don't think it can be done. I think you can borrow, but I don't think that the court intended that to be, and I think that we can in fact demonstrate, if we were to have a challenge, I think we would be able to defend on the ground that the Loft Board does have different purposes. So, these are people that are living illegally. What they're going to have to show as their residence is going to be different from somebody who is entering into a lease in a regular apartment. These are live-work spaces, so there could be differences on tax returns as a result of that. So borrowing is great, but I don't know about, I still don't think that just wholesale fits, and I don't think this case requires it.
Okay, I think it does because that Court of Appeals case, I believe the topic was actually primary residency.
Well, the topic was whether or not it was okay for the Loft Board to pass a regulation saying that somebody could be evicted if they were using the unit as their primary residence.
Okay, so there's another First Department case that talks about the Court of Appeals case, which I haven't sent you because I only got it recently.
Which case?
It's called BLF Realty. It's a 2002 First Department case. And I was reading it for some other topic, and I'll actually leave it with you. But there's a sentence in that case that jumped out at me, because that case was talking about the Lower Manhattan case that you're talking about. And the First Department says, talking about Lower Manhattan, the court also recognized the illogic of imposing a primary residence requirement after a loft is legalized and
After the loft is legalized. That's what the case is about, because that's what the argument that was made in Manhattan Loft.
but I think the full sentence, I think goes my way. Maybe not, but the court also recognized the logic of imposing a primary residence requirement after a loft is legalized and brought under regulation, but not imposing the same requirement prior to legalization. Basically I'm asking you to, well not you, but I'm asking that the rule impose the same standard for primary residency pre-legalization that is required after legalization. And I think the court is saying what I say the case says. But I'll just leave this with you, and you can look at it. Law and cases aside, I'm not understanding why you wouldn't use the same standard, because after all, these tenants are going to be subject to that requirement once they get a stabilized lease, right? I mean, why is there a difference?
Because I think the proof that loft tenants can offer is very different from the proof that somebody who entered into a lease for a rent-stabilized apartment can offer. Because a lot of times people don't even have leases. People don't necessarily have the same kinds of records. These are live workspaces, so there are differences in terms of the quality of proof. So again, I think we can borrow some of the standards. I think that that's a great idea. But in terms of just wholesaling, taking that whole body of law and saying, this is what you got to do, it's not the same. It just isn't.
Well, the body of law is well-known, well-established, easy to adjudicate because there's law out there. I would encourage you to think more about it and to look at the case that I'm going to leave with you. Now, the first department in the case that I did give you actually did impose the rent stabilization requirement in the Loft law context.
Which case was that?
That was in the same email that I sent to Lower Manhattan. But
The only thing that I got was the Lower Manhattan, and then I got the declaration. Was there another case in that
yes,
email?
one page after the
Oh.
is
I'm sorry, I did not turn it over.
it's Fishbein versus Matthews. Actually, it's not a first department case. It's an appellate term case coming out of housing court
Right.
that applies the rent stabilization standard.
I mean, there are, but I did find cases, older cases. I did find one appellate division case, but it's from 1996, 585 8th Avenue Associates, talking about, well, I guess that goes more to the privity question. But the original case that construed the Loft law, which was Workin versus Duncan, and this is right after the Loft law was enacted, talks about the fact that the variety of the transactions and the relationships which characterize the present Loft situation in New York City is very different, and that the reason that the legislature used the term residential occupant instead of using the word tenant, like it would under rent stabilization, was to provide elasticity and to free triers of fact from the stricture of the more traditional and stable housing arrangements. And the judge in that decision is actually citing as a source for that particular statement a seminar that she attended that was conducted by Carl Weisbrod, who was the first chair of the Loft Board, and Joseph, excuse me for mispronouncing it if I do, Fiocha, who was Joe Fiocha, yeah, who was the chief draft person of the Loft law. So they gave a seminar to housing court judges right after the law was enacted. So it seems to me, in terms of the intent, that the legislature was not intending to wholly bring in this analysis under the rent stabilization code.
Right. I mean, at some point, I mean, if we continue to not use the rent stabilization standard, where a person qualifies under the lesser Loft law board standard, but not under the rent stabilization, I suppose there'll be a lawsuit and we'll have an answer to that.
I guess so.
Yeah, but I would like to leave you that case and just maybe take one more look on it, and I certainly do appreciate that you looked at this so closely.
Is the case that you referred to and read to us from, is that B is LS, B is in boy, LS Realty?
BLF as in Frank. So it's
BLF is in
Boy Lawrence Frank, for lack of a better word.
Okay, so that was one issue. I don't know if anybody else has anything to offer.
I would just agree with the way that the case was described by Elaine, in that the original position in the lawsuit was that at no point prior to legalization of the building exiting the loft law and entering rent stabilization, only then could a primary residence proceeding be initiated against a tenant. That position was lost, and in fact, as you know, and you pointed out, you wanted to perhaps refer to current 2-081 of the grounds for eviction. There is very clearly stated a ground for evicting a protected occupant who, it turns out, is not using the unit as his or her primary residence. That's in the loft law rules now.
Right, but I guess our argument, so to speak, is how to prove that
How to prove,
primary residency.
right, well, the way it's set up now, it's dealt with in a court of competent jurisdiction, such as the case that you sent around before, right?
Yeah,
Well, I mean, I guess there's a difference between, I see a difference at least, between somebody being granted protection by the loft board and somebody who's already a protected occupant not using the premises as a primary residence. So I think what we're talking about here is the former, which is, do we grant somebody protection under the loft law? And if we're going to have a primary residence requirement, what that standard is going to be. I think Mr. Carter's advocating for one standard, I'm advocating for what could be termed a lesser standard, but I would say it's a different standard because of the types of proofs that loft tenants will offer versus rent-stabilized tenants in regular rent-stabilized housing.
right, and I'm not sure there would be a reason that the availability of proof would be different. And one thing that you did not include, and I'm wondering if that was intentional, was to look at the number of days per year that the person is actually living in the space. That's a major factor to prove primary residency under rent stabilization. I noticed that it was not in the list that's in the closed reg. And I'm wondering if you think if that factor should also be included.
Well, I would say if I thought it should be included, I would put it in, but
What does the regulation say, 6 months in advance?
it says
What does it
182
say?
days.
How do you establish, Mr. Carter, how would you establish that?
183.
How would you establish that? How would anyone be able to provide some thing to the
Well,
law?
this is a standard in income tax cases all the time. If you have a house 100 miles away, and you have from your office, and you have a house 1 mile away from your office, and there's a fight with the taxing authority as to which is your primary residency, right? And you're in your office every day of the year, every working day of the year, it's a pretty good presumption that you're living 1 mile away. I mean, I was a rent-stabilized tenant for many years. The landlord was pretty aggressive in finding out where people lived, and I had a second home. And my second home was 90 miles from my office. my apartment was 1 mile from my office, and in my daily diary, I had what I did that day. So I would always be able to establish it. This is...
So how does a person who occupies a live workspace establish that? They have a diary that says, I got up from my bed and I walked to my studio? I walked across the floor to my studio?
Elaine, that's not a fair counter-argument. I just happen to be telling you my example.
No, I know, but I just see that to me, that's the disconnect here.
Credit
Is
card
it-
statements, now everyone is paying with things, ATM, with you.
Yeah, that you go to the ATM
you-
near your house.
Oh,
yeah.
no, I see young people buying a piece of candy for 25 cents with a card,
Card.
right? And there's a record of that. So, you're at that store Monday and Friday, it raises the presumption that you're living near that store and not at your other residence 100 miles away.
So let me ask you a
Yeah,
question.
yeah.
And I'm not saying I'm in favor of it, but if we were to put in the 182-day requirement as a factor, would you be more inclined to vote for option one?
No.
No? Okay.
No.
I thought I'd ask.
Yeah, no. There are so many other problems in these options, but I think the 183 standard is a really good one because if you really live somewhere, you should be there most of the year. I mean, it's a pretty logical factor, and
But you're talking about, Mr. Carver, going back in a period of time, right? And you mentioned I don't mean to trivialize, but you mentioned the use of a credit card, for example, to make purchases. I mean, you're talking about going back for so many years back to the time and establishing the use of a card. I know there must be other ways, but wouldn't that be some burden, not just to that tenant, but onto the Loft Board in terms of establishing?
well, the tenant might want to do that. I mean, you're assuming that the owner would actually use it against the tenant. But that seems like a very useful thing for the tenant to say, oh, wait a minute, I lived here 183 days of the year. So I don't know that it's biased against the person who has to prove it. It actually may be helpful. And because no one factor rules, having that factor might be helpful. Something to think about.
Other members?
One observation that I'd just like to make, and it doesn't necessarily lead towards leading in one direction, but I think we have a responsibility as a board to try to simplify this as much as possible for some of the very reasons that were brought up here. I know myself, just in trying to prepare for this, I spent numerous hours reading through all this, compare this to this, and that to this, and what have you. And you can kind of find yourself going all over the place. So kind of leaning towards what has been said on behalf of the tenants. If I'm an artisan and my job is to get up every day and create sculptures or portraits or something, my specialty is not trying to determine how I piece this all together to prove my point. And I guess what I'm trying to say, again, not necessarily being all in one way or the other, but I think we as a board should try to simplify this. And if there's data out there, if there's law out there that says that this is how we define this, to me, simplifying it is including that in with ours. So if a tenant does come across this issue, or even an owner in preparing for something, that they don't find themselves or their attorney spending endless hours drawing this piece from here to try to figure out how, you go to this. So I'm leaning towards simplifying this. That's what I want to do. I want this to be simple for both tenants and owners alike, so that they don't have to exhaust endless hours in a realm that's not, they're not familiar with, to be able to come before the Loft Board or to be able to deal with their issue.
I think the way to simplify this is to keep the Loft Board out of primary residence cases and let them go where they currently go, which is housing court. You take the 183-day provision. That potentially makes some sense if, as Mr. Carver describes, I have my office, I have my rent stabilized apartment a mile away, and I have a home in Connecticut where I might want to vote in Connecticut because I'm involved in local politics, or I think that I'm going to have a tax advantage by listing different places my primary residence. But there are loads of people. I was talking just the other day with somebody who pointed out one of the people in his building is a pretty successful musician who's away from his loft more than 200 nights a year, but he's not in Southampton for 200 nights a year. He's in Berlin for a week and Tokyo. So, and in particular, part of the reason that making this what is now close to a 10-year demonstration of primary residence during the window period on the effective date of the act, and if there's an adjudication at the point of adjudication, is that this is just not the way that people live. And if you end up with a coverage case in a small building where Joe the musician's qualifying as a protected occupant is central to the case, to have all the other applicants tied up with this proceeding before coverage can be determined just makes no sense. Have the building registered, register the occupants. If I'm a protected occupant today, but tomorrow the landlord brings a primary residence case against me in housing court, so be it. I agree that you should be using your loft as a primary residence, but what that means, there's such a host of different cases that for us, and Oath, which doesn't have the same automatic powers of conducting its business as court does, I just think this matter belongs in court. That's the way to keep it simple.
Chuck, I just want to point out that when a person works, a person who travels for work, that issue has long been settled by the courts as to how to handle the counting of days. So we've got 30 or 40 years of law. All the different permutations have already been adjudicated, which is why I think we should pull in the rent stabilization statute.
Well, and I would say that, yes, it's been adjudicated, and let the people who are expert in dealing with those cases continue to deal with them.
Anyone else?
There's a different flexibility here with the law firm or somebody that's using their apartment to working. So I don't think that the comparison should be simple. I mean, an artist may work 60 days a year but live there. So you can't say that the going to work is the determinative factor, as you did, keeping the log, on every day that...
No, that was just one example of how to count the days. That's all that was. That's all.
Then on the other hand, I think I brought this out, it could be that one of the former mayors of New York that had houses all over the place. I'm not sure that that mayor was here.
He was a loft dweller.
Only maybe in one house, but
it's a-
certainly not here.
The number is, I wouldn't say it's totally arbitrary, but I don't think that should be the determining factor.
Well, I think it seems to me that what Mr. Carver is saying is that we should list it as a factor.
No,
And I'm saying,
no question, yeah, but not the determining factor, that's all. And, as far as, I have one son that's been living outside of New York City, his 917 phone number, all these years, never changed it. And you also might have had a credit card for some time that he was living someplace else. So I don't know whether those things can be determining factors. I mean, you gotta take in the whole, you gotta take in the whole picture here. And if there's a problem, I agree with Chuck. You know, House of Court and adjudicate it and see what happens.
But the issue, I think, is whether or not, I mean, I think it's fine for somebody who is already protected, and there's a suspicion that they are in fact not using their loft as a primary residence, then I think it's fine to say to go to housing court. The problem that I'm having, and maybe you guys don't have it, and that's fine if they're your rules, and if you want to go that way, that's okay with me. But the problem I'm having is giving protection to people who aren't actually living there. And we've had a few cases where that happens. And in terms of the quality of proof, I mean, staff sat down after the last meeting and we really went through all of the recent cases to say, well, you know, what are people coming forward with? And is this going to be a burden that we shouldn't be placing on tenants because it's not there now? It's just possession, unless you're a prime lessee. You know, and for the most part, it came down to an all or nothing analysis. There were really, the only borderline cases that we could come up with were the cases where people were traveling for work or Peace Corps or whatever. So, you know, it hasn't, in terms of presenting itself in at least the recent cases, people are coming in with lots of documentation and testimony, incredible testimony, that they're living there. So we really haven't had a case where it was kind of maybe they were, maybe they weren't, how many days was it? You know, we never kind of get to that part of the analysis. So, you know, my concern is the none, to be perfectly honest. That's my real concern, because I just can't see protecting people that aren't there and are testifying on the record that they're not there. So that's my concern. That's where this is coming from as far as I'm concerned. So.
Well, the other component of the primary residence question, again, is asking people first to document the window period, where they may have been induced by the landlord at the time to provide evidence contrary to fact. And the whole reason, there's no window period in rent stabilization. You sign a lease, you're a rent stabilized tenant. The whole purpose of the window period was to say that if there's been a sufficient period of time where you've lived openly in the space, that demonstrates that you were using it residentially, regardless of language in a Bloomberg lease that said loft studio is permitted by law, or no living allowed, or all the various kinds of phrases that landlords put into these leases to try to protect themselves against the danger of the multiple dwelling law coming into play at some point in time. And the original court cases before the loft law, starting with Lipkus versus Picus, it was the finding that these people had lived openly in the buildings, and if the landlord claimed he didn't know, then he wasn't paying attention. So if there's, when you're dealing with some of the coverage cases where we've had people say, oh, I haven't lived there in a couple of years, in rent stabilization, the period that's looked at, I believe, is 2 years from the time that a non-primary resident case is brought. Here we're asking people to go back close to 10 years, hit 3 different points in time, and have good solid documentation for all that. That's asking an awful lot of people.
It's not only documentation, it's also
We get a lot of
sworn
testimony.
testimony,
We get a lot of testimony.
witnesses. It can be done, it's done all the time.
Am I right, though, from what I'm hearing from Elaine, was that it's kind of much to what nothing here in terms of focusing on that?
Well, I think over the next few weeks, Elaine will look at the other case,
Mhm.
and we'll think about whether or not it makes, and you'll speak to staff, obviously, whether the 183-day threshold is something that we want to pursue, because it is not necessarily anti-tenant. It actually might be helpful to either side.
Okay, I mean, I'm certainly willing to do that. So should we move on to privity? Yeah, okay, so in terms of privity and this concept of privity, so again, did some research, went back, looked at older cases, and there are a couple, one from 86, which is a Supreme Court case, but there's a First Department case, 585 8th Avenue.
So in terms of privity, this is a response to my argument that 286 2I would preclude
People who are not in privity with the landlord.
Okay, yes.
From being protected occupants.
Okay.
Yeah. So we have a whole slew of loft cases that talk about privity and privity. You don't need privity. But the case that I found, which I think was the best demonstrator of that, was, again, Appellate Division First Department from 1996, 585 8th Avenue Associates. The applicable regulation provides coverage for residential occupant in possession of a covered residential unit, even if the occupant is not a prime tenant, even if the landlord did not consent to a sublet, assignment, or subdivision, as long as the occupant was in possession prior to the effective date of the law. And then there's the older case, Gordon versus Batista, which is an 86 case, which specifically says the loft law was designed to protect all residential occupants, whether or not they are in privity of contract with the landlord. So our cases say the same thing in terms of roommates, in terms of spouses. We've had a series of cases, even since the shift in the protected occupancy analysis, where you had people who were basically leasing a room and had access to the common areas from a net lessee. So those people were not in privity with the landlord either. They were in privity with the net lessee, and the board didn't cover them. So maybe there's this distinction there that I'm not seeing because I'm not a real estate lawyer, but it seems to me that over the years, we have not looked at privity, and the courts are instructing us not to look at privity.
Okay. If I could take a look at those cases, and we can talk more about it next time, I suppose.
Sure.
Okay, great.
Sure. Okay. I'll send them to you. Yeah, I'll send them to everybody.
Yeah.
Do you want all the roommate cases too, or you just want the court cases?
Just from the courts.
Okay.
Yeah, thank you.
Okay. Okay.
I think to that end, it would be helpful if there are both law board cases and court cases that you folks are looking at, if you circulated things to all the board members so we kind of have a common body of knowledge to work from.
I have no problem doing that. I'm concerned with overburdening, because I could be sending you like 50 pages of, 150 pages of things, so that was maybe...
You do that every time you send out cases?
I know, but it's cases. I mean, you need that information. So I will be more than happy to send that all.
Before we move on to the next topic, can I ask just a really elemental question? Now that living with a black and white printer, I don't have the experience of...
Green?
What's green and why?
Green
and
was...
what's yellow?
Okay, so on the first couple of pages, the things that are yellow are things that we have to fill in dates and stuff. So
Right. Got that. That I got.
The green are things that change from option on the statement of basis and purpose. Okay.
Okay.
The green highlights are things that change from option to option, because if you're doing a different option, then you need to have a different statement of basis and purpose. And then on the rule itself, I changed a heading, I added in a line pursuant to the discussion last time, and then I added in that whole section 4. So that's stuff that I added in. So I just wanted to highlight that, so this is new. It's my way of saying this is new. So green doesn't seem to be a very good color, actually, because it photocopies poorly. So
You can say that again.
yeah, I'm going to use a different color next time. It happens to be my
So you're
favorite
gonna
color,
have to
but
ask
I'll
this
use
question
different.
again next time.
Baby blue
Colors
or
are changing.
something.
No, no, I'll let you know.
All right.
Or I'll use a lighter green. So that's all I have to say in terms of the discussion from last time. So if we could go on with option 1, or if anybody wants to move to option 2.
Well, as far as option 1, I mean, we exhausted discussion.
We did have one thought about sort of combining options 1 and 3. Option 3 kind of originated as a middle ground, but also from the concern that I think Mr. Carver expressed, in that we had this court case that was circulated to everybody about the number of people and exceeding the MDL. So we were actually thinking about incorporating the common household standard into option 1 to the extent that if there would be more than the number legally allowed under the law, then the board and ultimately would be required to make an inquiry into a common household and use those factors. So we were thinking of sort of moving option 3 into option 1 that way, just so you'll know.
I had a bunch of language comments that I sent you on option 3, but I think that are applicable to more than option 3. I'm wondering if that's something we want to go through with the board, or I could explain the concept that I was driving at with those changes, or the loophole that I was seeking to close. And
Yeah, I just didn't want to send them out because
yes.
I had already sent out these. I
Yes,
figured I would
yes,
change
yes.
them.
Yeah, of course. So that's one thing we might want to talk about. I also had some thoughts about, since option 3 is the one that you're now recommending.
I don't know that I'm recommending any of them. You know, I was asked to come up with something, so that's what we came up with. And I'm not sure.
Okay. I had some global thoughts about the whole concept of option 3 to share. But just in terms of, do we want to talk about that first? Do we want to talk about word changes? Do you not want to listen to me? And listen to someone else, that's fine too.
I think word changes.
Word changes first, okay.
Wait a minute, you suggested some language changes
Yes.
that you sent to Helene?
Elaine, which.
I'd be happy to talk about them at the next meeting. I'm not interested in talking about language changes on the fly.
Okay, would you like me to talk about the concepts?
Sure.
Today? Or not? Is that amenable?
What if, this is a board meeting.
I'd like as much information from all directions as anybody has time to stay here and give, so that's my position. I'm open to hearing everything that's...
Right, my only point is, we're kind of, last meeting, we talked about a document that I had not seen till I walked into the room, and that even if a board member checked their email every 5 minutes, they would have only had in their possession for something like an hour and a half. Now, if you have suggestions to modify number 3 that you shared with Helene, I think that's great, but I think in terms of everybody being on the same page, stuff that comes in either needs to get circulated beforehand, or then it's kind of like...
I get your point there, but I mean, what's the point of it? It's not like we're making a final decision here, it's a public discussion, so why can't he express whatever he wants to express
Sure.
in the context here, and we're not making...
I mean,
I'm happy to listen and take notes, but I'm not in a position to respond.
Right.
I mean, so I can talk about that, or I have some global issues with option 3 that...
Why don't you start with global issues?
Okay. So, it's not clear to me what the problem is that you're trying to solve. And the statement of purpose, I don't think was helpful either. So I thought about, okay, what is the state of affairs now? So now, if a prime lessee exists, the prime lessee is a protected occupant to the exclusion of all others. And that sounds a little harsh, but when you look at the succession rules, which will be circulated,
Right.
those show that friends and family basically have a right to succeed the prime lessee, so that in the event that the prime lessee leaves, those other people are not left out in the cold at all, right? They have,
If they've been there for the requisite amount
Or-
of times, et cetera.
Get to 1 or 2 years.
yeah, it's for a
Right,
short amount of time.
right.
So in terms of a compromise, I think that was the compromise. So I think, people in good faith who were looking for a compromise, it already exists. You've got a right of succession for a whole host of people. They're just not called the magic word, protected occupant. But they've got pretty far-reaching rights there. So,
I'm sorry.
Yeah.
What happens to their rights before the succession event happens? I'm a lawyer here, but I just want to, succession happens at what point?
if the prime lessee leaves,
So what happened to their rights, the occupants during the period of time before that?
okay, so like in any other area of life and real estate law, if you're living in someone else's apartment or someone else's lease, you're bound to their circumstances. Now, let's think about a child. Okay. A child is 10 years old, 11 years old. He's in occupancy on the magic date. He becomes protected occupant under your rule. The parent who's on the lease is going to be very surprised to find out that the child has equal rights to occupy that apartment. So if the plan was when the child is 18 to move out of the parent's own apartment, the parents have a lease. The parents I think, would be pretty shocked to find out that Junior has the right to be in that apartment for the rest of his life. The same goes for Aunt Fran, right? So Aunt Fran was living with the family, with the lessee who was helping out the aunt while she got the uncle when they got their act together. And lo and behold, they were in occupancy on the date, and it's going to come as a shock that the leaseholder is now stuck with Aunt Fran for the rest of Aunt Fran's life by having the same legal status under your proposal. Your proposal is not recognizing the rights of a lessee to control the unit that they in fact lease. So the compromise, the fact that you've got protected occupancy limited to the lessee when you have a lessee, and the rest have other rights in the event the lessee leaves, that's a pretty good compromise. It recognizes the lessee's rights, and it gives a helping hand to the friends and families who live there in the event that the lessee leaves. So the compromise that we're all seeking, I think, exists. I think it's perfectly fine, and I'm not sure why it needs to be changed. In a related issue, if only the lessee is obligated under the lease to pay rent, what happens if rent isn't being paid? I mean, does only the lessee get evicted and the rest stay, who have no legal obligation under any lease to pay the landlord? How would that work?
Well, wouldn't it all depend on whether or not why they're not paying rent? I mean, if the landlord's out of court
No,
complaint.
let's assume they're just not paying, you know. What happened then?
You mean the lessee's not paying, but the other non-lessee?
No one's
Oh,
paying.
no one's paying.
No one's paying. You now have 25 protected occupants and one lessee. What happens
I don't know.
under your rule?
I don't know if that's the way I read it, but if an 11-year-old kid is living there and then goes up to be 18 and moves out,
No, let's assume he's not moving out. He's there.
there from the age of 11 till, let's say, 55 when his parents die.
No,
I mean, it's a hypothetical, it's just, I can't deal with it.
No, but this is all.
It's unrealistic.
It's not at all. It's the same as any other occupant under this new proposal. The lessee is stuck with them for the lives of those occupants.
Or would the other occupants be paying, would have to pay rent, right?
Well, I'm asking you, under your proposed rules, if rent is not being paid, you have only one lessee, and you have 25 other protected occupants, what happens? I don't know. I honestly don't know.
So
My understanding is if an owner is not getting rent, he has recourse in housing court to bring a non-payment action, and he can name the prime lessee, which is the person who he's in or in contract with. And what he does in the caption is that he sues Jane and John Doe if he doesn't know the names of the other people who are there. So, and he can get a warrant, a judgment against those people, or against the prime lessee, and a warrant to evict everyone in the house. At least that's my recollection. It's been a couple
So
of
they
years.
have an obligation. They have an obligation to pay rent under a lease that they haven't signed. I don't know. I'm just
I mean,
asking.
they can, I mean, an owner can bring a holdover, he can bring a non-payment action. I mean, there's recourse in housing court if what the owner wants is possession of the apartment. I mean, my understanding is that he can bring a case under aliases if he doesn't know the names of the people who are living there.
No, I think in some ways that's a good question. If the landlord accepts the payment of rent from Aunt Matilda, then I would think that Aunt Matilda has the right to stay there. But if he doesn't accept it, then that's another question.
Now, once you've got 25 protected occupants,
Can you be more realistic?
Well, there's a list there, grandparents, grandmas, stepsons, stepdaughters, and so on and so forth. I don't know whether that adds up to 25, does it? Did you count?
yeah, it's possible in that way. It's possible in succession.
well, they could all be a family though, I mean, right? So,
Is there a mechanism to unprotect, prior to a stabilized lease being issued? If it turns out that someone leaves occupancy and it's no longer a primary residence.
yeah, the landlord could take them off and put somebody else on. I mean, that happens. Usually the problem is the other way around, that the person that was named as the protected occupant leaves, and then the landlord never actually updates the records, even though other people are living there, and the landlord is accepting rent. But the landlord could update the Loft Board's records to say this person is no longer there, and now we have somebody else living there.
But you accept that representation from the owner, is that the process?
Yeah, I think we would update our records when we
The representation that there's a new tenant.
Know that a particular protected occupant, they formally found protected occupant no longer a primary resident.
Usually it comes with the sale.
No, I don't think I've ever seen a situation in which an owner has written us and said, this person should not be the protected occupant because they don't use the space as their primary residence.
This is a real possibility if we have,
No, I've never.
if we have 25 protected occupants.
Well, but if they evict somebody, right, if they take them to housing, plan and evict them.
That's sometimes, sometimes we don't.
The record keeping in the loft world on both, I think, the owner and the tenant side is not necessarily what I would want it to be.
Right. Now, you definitely need the primary residency requirement at the point that the stabilized lease is issued.
Well, I would argue that the law requires, I mean, the loft law itself requires primary residency. Right? I mean, that's my argument from the get-go. You're allowed to continue as long as the continuing occupancy is, as long as it's your primary residence, so.
Right, but as drafted, you kind of have an end date with the date the record closes.
Because there's no way to know after that. In other words, I'm talking about what I'm trying to get at in the rule, and maybe I've done it inarticulately, is that when the board is evaluating a primary residence, a protected occupancy application, what the board is going to have in front of it is the proof that was offered at the trial. So we're not going to have anything from after the record closes, which is the law, actually, right? The rules say you can't consider anything that's outside the record anyway. So that's all the board's going to have in front of it, so it doesn't make sense to have something else. So that's why I chose that particular phrase. I'm not wedded to it, but it seemed to me, if you're going to put in some sort of a time frame, what is the board going to be able to look at? That's what they're going to be able to look at, whatever was in the record. So, what happens after the record closes, we don't know what happens after the record closes. And I guess that would be the situation where the landlord could find out after the record closes that there's an issue about primary residence and maybe bring an eviction proceeding in that situation. But the board shouldn't be considering that because the rule says you consider what's in the record. It's a quasi-judicial proceeding.
Should the rule elsewhere, though, state that primary residency is required at all times thereafter?
Well, the law says that, so we can certainly add it if you feel it's not specific enough now, you can certainly add that. But the law says it, so I don't know that we have to have a rule, but we can. I'm certainly not against it.
Any response to my contention that you're unreasonably infringing on the rights of a lessee to actually control who's in their apartment?
I think to the extent that the lessee is letting these people in, the lessee is taking that chance. So the lessee has made a decision to let somebody move in, for better or worse, right? And people do that all the time. So they are taking that, are you saying that they didn't understand that these people could be protected under the loft law?
Yeah.
Leslie is saying
Oh,
they didn't
yeah.
understand.
Oh,
So,
yeah, this is nuts.
would some sort of grandfathering provision alleviate that concern? So that from a certain date, moving forward, which I hadn't thought of the rule being retroactive anyway, so. You know, people are on notice that this is a possibility.
I guess it somewhat alleviates the concern, but it still doesn't stop the rule going forward from being unreasonable in my view.
You know, I have to say, although I guess it's different when it's in your own apartment, but, you know, some of these cases that I was reading in terms of like the subdivision cases, I mean, you want to talk about nuts, like, so you have the net lessee who rents a space to somebody else who divides that space in half, and person A, right, keeps their half and rents the rest to person B, and then person B subdivides into 3 separate units. So now you have A, B, C, and D. So C and D are paying B, B is paying A is paying the landlord. I mean, so you have a lot of these, there were a lot of these cases, particularly in the subdivision area where it was just wild. And one leaves, another comes in, and it was really hard to follow. So, I don't know, but those are subdivided units, so I guess it's not the same as having somebody living in your house. But then, of course, the question is it really their house? If it's a loft and they're protected under the loft law. So it's a different animal. Again, you know, are you thinking of it as a traditional apartment? It's not a traditional apartment. It's just not. It's just different.
But concepts of real property are still apply, and it's. I wonder if even constitutionally you can take these rights away from a lessee like you proposed.
But under the current rule, right, if the prime lessee isn't there, anybody who's there gets covered, right?
Okay,
I mean,
right,
anybody who's there at the applicable
but-
time, if the prime lessee isn't asserting coverage, or if the prime lessee is asserting coverage, but we find that they're not using the unit as their primary residence. So this is happening now,
But
isn't it?
I understand, but I'm just talking, but the existence of the prime lessee legally, I think, makes a huge difference. So let's just stick with that scenario.
But what rights are you taking away from the property? You mentioned you take it away.
The right to control who's in the apartment.
I can't evict my 10-year-old daughter, to follow one of your examples.
But you could
evict an 18-year-old.
But you can evict when they're 18, 19, 20, 21, 22, and up to 100. And the owner is now has the child for life.
Well, the owner could have the child for life anyway under succession,
Could,
right?
could. And I said, but this is for sure. This is for sure.
I have to say that I think some of the kind of scenarios that you constructed don't really take into account the way these lofts are being used by people. And particularly, we're down a couple members. Hopefully we'll get some new members sometime. I think it would be beneficial for the board members, if it can be arranged, to take a look at some of these lofts so that we have a little clearer understanding of what's involved. And again, I don't know of a unit with 25 people, so I think that's a bit of an exaggeration. But there are lots of units that, and I've said this before, where yes, one person holds the lease with the landlord, but they all contributed to building out the space, they share the rent. These are very creative living situations, and it's not as absurd as the picture you would paint.
I think the concept of helping to build out is a vestige of the older cases. I don't know that that's necessarily happening in the the current cases. But this rule does not rely on the sweat equity of anyone.
Only to the extent, well,
That's for sure.
if you're talking option 3, there's a factor about sweat equity, but it's not solely sweat equity.
Yeah.
Chuck, when you propose that the board take a look at laws, could you define that for me, what your thoughts are on that?
Yeah, right after the law passed initially in 1982, we arranged to have a tour of Loft units for members, particularly the public members who may or may not have any real experience with what's involved. So, and we did it again, I'm going to say in the mid-1990s when there was a significant turnover in the board, because the reality of how live workspaces are used it is hard to grasp if you've never really had a chance to take a look at some of these.
Has there ever been a time in the history of the board that the board's actually conducted, actually allowed the people that it affects, both owners and tenants, to speak and describe some of the situations? Do you recall? Or?
Well, the answer to that is yes, in the sense that when what were then called regulations were first being written, there was extensive public testimony, as I think there will be at hearings, as I think there will be on whatever changes to either revising these rules or the new Chapter 1 and Chapter 2. I think there'll be quite a bit of people coming forward to offer their experiences. And, you know, with regard to Helene talking about some of these crazy subdivision cases, the reality is it all worked out pretty well. And the landlord who was getting $500 from Space A, who now all of a sudden saw the rent coming in from these subtenants who had been granted privity with the landlord, it was to the landlord's economic advantage as well. So, despite the way that one can postulate this could cause a problem, that could cause a problem, actually, the laws work pretty well and there haven't been that many problems.
Can I just say that I would welcome public testimony in the context of passing the rule. So very big on getting public input at the appropriate time.
Is it, Mr. Chairman, is it possible to arrange, and forgive me, I'm probably using the wrong terminology, but it's the only one I'm familiar with, some sort of a town hall forum, if you will, where both owners and tenants could speak?
Outside of the rulemaking process?
Well, yes, outside of the rulemaking process, but for the purposes of, I mean, it's easy for me to set up here in a fire department uniform and 36 plus years in the fire department and know that I've crawled down hallways and carried people out of burning buildings and such, but most of those folks out there, unless they've been volunteers somewhere or retired, they probably have no comprehension of what a firefighter really does. Just as I've never lived in a loft building, I've visited many of them and inspected some of them, and I've never had the privilege of owning a loft building, so I don't really, despite the fact that I believe at the end of the day the law is what matters, I see a certain advantage to being able to understand, you know, right from the mouths of those that affects both owner and tenant, you know, in the process of looking at all this and bringing it together and making a responsible vote on which way we're going to go. But I don't know if that's even feasible. That's why I asked for some historical perspective on it.
I hear you. I certainly, in a town hall, as I said, it's just.
Well, that might be an inappropriate term, maybe.
Okay. Explain what you mean by that.
Well, just where, I know we have these public meetings, but sort of, in my opinion, sadly, the public really never has an opportunity to speak. So we don't really ever hear from the owners and the tenants, other than when we're over, when the meeting's over. Some sort of a forum where prior to, so that it doesn't become like some sort of a free-for-all, the tenant's rep could maybe contact 3 different people.
I don't believe we'll be able to visit people's apartments as a
Well,
board.
no. I was referring to where they could come and stand behind a microphone and express,
Have you had any such?
and also,
Stuff like that happen?
There are a few times that there have been usually organized around a topic. Representatives of the various communities have been invited to address something other than a pending rule or
A
regulation.
couple of public meetings years ago in the boroughs, which I attended. I think it's not a bad, the thing is that there are so many people, not only in lofts, but in low-cost housing that are living under the radar anyway, and I don't know why we have to begin to sort of particularly focus on this. Maybe that's not the right thing to say. But that seems to be the case. And those, for example, that are living under the radar in low-cost housing here, nobody knows about it, nobody cares, and they just go along, and they sort of live there, and they share rent, and they don't share rent. And indeed, I remember when the first loft law came into effect, there were a whole bunch of artists that didn't want it because they had preferred to live under the radar. So, I mean, there certainly was a little bit of a horns of the dilemma here as to exactly what to do. And I don't really see that there's a whole lot of problems with the way you outlined this in the 4 or 5, what was it, 3?
3.
Yeah, 3.
let me just clarify. So I'm not advocating that we put up billboards and encourage people to come out from behind, closed doors, but we have quite a few familiar faces that I've seen at numerous law board meetings that obviously either represent tenants or their owners. And it seems to me if they take the time and the initiative to come to these meetings on a regular basis, that they may be willing to express their perspective as to what their needs are, et cetera, as a tenant and also as an owner.
Can I just address that?
Sure.
I have 2 concerns about that. The first concern is that what people say could involve pending cases. So I'm very concerned about that, because once you open that door, you could wind up hearing things that you're not supposed to hear. So that's one concern that I have.
Point well taken.
The second concern that I have, well, the second comment that I have is that the City Administrative Procedure Act has a rulemaking process. That rulemaking process incorporates public comment. After the public comment, the board has a right to change the proposed rule as a result of that public comment. So the time to hear that information is during the CAPA, in my opinion, is during the CAPA process. So, I know that there are people that are out there, no, you should be listening to us now so that you formulate something, but I think that you have to start somewhere, and the board can change and tweak the rule after getting that input.
All right, point taken.
And you start with the law.
Thank you for clarifying.
Okay.
I have my own thought on
Just
this.
before you go, Mr. Carl, I think just to follow up on what Hernán just said, certainly members of the public can reach out to the different board members in order to kind of make their case, whether it be after this meeting or in some other way, if you want to offer up your contact information. And you board members can make those cases during the board meeting.
Yeah.
Yes.
Okay, so other than public comment, there's this issue of fact-finding, I suppose, that you're talking about. And I actually think we do need to do some fact-finding, but it's actually not on the issues that we've spoken about so far. The sale of rights section that's proposed could potentially be a groundbreaking change in terms of owners not being able to buy out of stabilization and tenants not being able to receive buyout money. And I really think we need to understand what's going on there, and I think that's beyond the capacity of us, of members, just to hear from people here and there. I really think we need to bring in 1 or 2 owner reps, 1 or 2 reps for tenants, and maybe someone who's actually studied the housing market to really properly explain what the effect of the buyout rule change will be. I really don't see how we can vote on that.
Why can't that be done within the county?
Because we need to interact with these witnesses. There's plenty of, there are plenty of people who deal with this issue every day. My understanding is that in the first department, which is Manhattan Bronx, there's a case, I think, that is consistent with the proposed rule. And I believe in the second department, which is Brooklyn, Queens, Staten Island, that rule is not followed. So we have experience. We have a bunch of buildings with the proposed rule going on, and we have a bunch without. And I would really like to hear from people in the field to better understand what the proposed rule would mean, how that would change what's happening. And this is not necessarily a pro-owner or an anti-tenant rule. I think, I don't know that owners or tenants want it. That's my sense. I don't know that that's true. But I would really like to hear from people testimony. It could be short. It could be just at one of these sessions. And that way members of the board could actually interact with the witnesses. That's my thought on in terms of having members of the public interact with us at this stage. I would limit that interaction to the buyout rule.
So you're asking us to get some expert made testimony as to the impact of that before we consider the rule.
Yeah.
The other members? Yeah.
I'm not opposed to that, but if I understood you, your definition was that we really couldn't do that.
Well, no, I said we can visit. We can't visit people.
No, I was referring to Helene had made a statement regarding the proper administrative process, and that would be done after the rules are actually voted on, that then you would have the hearing.
So I think the sale of rights
Is that
is,
it?
I'm not as concerned about pending cases in terms of sales of rights, because there just aren't. So that's my primary concern. I mean, normally you would have the public hearing during the capital process, but if the board really feels that they just can't go forward and fashion a rule without more information, at least in terms of the economic impact of this, which I could understand, then I don't think that there's any law that says you can't do that. I'm always hesitant to do it. That's just if the board wants it. As opposed to the other rule where you really run a risk because we have a lot of cases.
I respect and appreciate that. I think we've done that.
Yeah.
Anyone else?
My experience has been that sunshine is always a good thing, and particularly in our quasi-legislative function, it's certainly not uncommon for either state or local or federal legislators to hold fact-finding missions, travel to places, speak to people prior to crafting legislation. So particularly, again, with the way the board evolves as new members come on, how are they supposed to have enough information to form an opinion? So I tend to be in favor of that sort of thing.
Right, I see. Basically, your point is that theoretically, one of the vacant seats could be filled with somebody who has never even been inside a loft before and
we've had a lot of public members who have never been in a loft and sometimes weren't very interested in the subject, so.
Okay, Mr. Barber, do you have something? Do you have anything else? I'm just giving everyone a chance.
No.
Okay, great. I'm going to take that back and discuss it with staff and see what we could probably do to accommodate that. So I'm getting it that a majority of all members here are in favor of some sort of arrangement where we can get, as Mr. Carver described, correct? Do I have to repeat that right the way he described it, right? Okay, very good. So we're going to stop our meeting here, which includes Patty.
Yes? Yes.
I would really, I have a couple of general questions, but before we do that, one section that we have not spent any time with that would be helpful for me is the distinction between the little triple I under 3 in 208.
Which option?
I think they're all the same,
Oh, okay.
as far as I can tell. And I just, for the life of me, would like an explanation of what the alternative is intended to do and how it differs.
Is it on page 6?
In option 1, it's on page 5.
Page 5.
I believe it makes proof, it actually specifies what the proof is. It has certain bright lines as opposed to a standard. I think that's the difference.
In the DEF section.
Yeah. In other words, it's adding in the material from 3 little I, right, at the top where you're putting, we inserted additional language. So it's adding in that additional language to the person that is there after the effective date of the law, but with owner consent.
Right.
So. So the first is just the date, and the other is the date, and you have to show these things.
Okay.
But one of Mr. Carver's comments, and he was correct, is that you don't necessarily need this for all of the alternatives, because if you have it up on top, you don't necessarily need
Right.
it below.
Okay. And you mentioned the question of, we're considering amending these rules. We kind of have on the back burner a complete kind of look at all the rules.
That was my original intent.
And you mentioned the question of what, if anything, would be viewed as retroactive. Could you just, and we've got...
I don't think anything should be retroactive. When you do rulemaking, it usually goes forward.
Right.
To the extent that there are, I think, I mean, normally when you think about, when I think of the term grandfathering, I usually think of it from the zoning standpoint, where something was there before and you let it stay. So to the extent that there were agreements before, you let them stay. So that's what my thinking was when I used that term. I'm not sure it was the right term.
Right, okay.
In this context, though, moving forward, would it be as for new applications coming in? This is kind of tricky.
Right, exactly. And at the moment, for overall coverage, there are no new applications.
Well, again, this is about protected occupancy, not coverage. But there are some pending applications, and we have pending protected occupancy applications.
I'm sure there are proceedings going on at Oath
Right.
that would turn on these potentially. So I just was curious if the staff has had time to give thought to that.
I mean, normally when you do a rule, the rules you apply that rule from the date that it's enacted forward, because it wasn't in effect before that, so you can't kind of look back. So I think for the people where the applications are currently pending, they would have to go under the old rule, which is sort of bizarre. Maybe they would have to withdraw or refile, I don't know. If it would be advantageous for them to do so. Clearly, a coverage application is not going to be withdrawn because it can't be refiled. refiled. But a PO application can be withdrawn and refiled, I guess, if the record hasn't closed, certainly.
Okay.
In terms of witnesses, if we want to go that route on the rights issue, I wonder if board members could actually recommend witnesses to you.
We would actually rely on that.
Oh, okay, good,
Yeah.
thank you.
I don't think we have those connections.
Okay.
Before we adjourn, I just have one question, which is, are we clear on the December schedule? At this point, I know there's a question about morning versus afternoon on, I think, December 28th.
Oh, so I'm still waiting to hear from two members who are not here today, surprise. But it looks like it's going to be the afternoon. The preference seems to be for the afternoon on the 28th.
28th.
And
The 30th is morning.
Right, November 30th is in the morning.
The others should all be in the afternoon.
And do we know the location of?
Here,
They'll all
everything's
be
going to be
here.
here. Everything's
Okay.
going to
Yeah,
be,
we-
we're moving here.
Okay. All right.
Never throw your old home away.
Just try to evict your 10-year-old.
I never suggested that, Chuck. It was the 18-year-old. Eventually, the 10-year-old becomes 18.
I'm aware, but there were moments when I certainly would have considered evicting my 10-year-old at the time. And my last comment is, I waited for the mapping presentation, and while I think the mapping presentation is very interesting and will provide a new tool, I am still concerned that we're not getting the kind of reports that we used to get.
I sent you the spreadsheet.
Well, I just pulled out some samples of what I have in mind. For example, the number of pending cases, that kind of thing.
Oh,
So,
okay.
so I just
Yeah,
thought I'd provide both
absolutely.
you and the chair with, these are reports from 2014 that,
Okay.
Oh, Sam?
yeah.
And these were quarterly?
I would say they were kind of sometimes twice a year, sometimes 3 times a year. But I think it would be very helpful to have a sense of that information.
Okay. I'm all in favor of it. If you tell me what you want, I'll be happy to.
One last thing, Clay, I'm sorry.
Yes.
We keep saying one last thing. Is the plan for you to send some new language around?
Well, I'll circulate the language that you sent, because everybody wants to see it.
Okay, but is that something that you want in there? In other words, is that something that you want as part of the rule?
I think that you had excellent suggestions, and everybody should see them.
Okay.
So, do I agree with all of them? No.
No, okay,
But I think everybody should see them.
That was my question. All right.
Okay?
Is there another final? This will conclude our November 16, 2017 Loft Board meeting. Our next public meeting will be held here at 22 Reed Street, first floor conference room on November 30th, 2 weeks from now, at 11 a.m. We will discuss cases at this meeting, and if time permits, we'll also discuss the rules, but our primary is going to be cases. Thank you, board members. Please attend your attention.